All right, you can get started.
Great. Well, good morning, everyone. It's a pleasure to be with you, albeit virtually, wherever you are in Georgia. I hope the day is as beautiful for you there as it is here in Atlanta. My name's David Kirk. I'm a partner at Troutman Pepper Hamilton Sanders. Some of you may remember I was a partner at Troutman Sanders a couple of years ago, but we merged with the Pepper Hamilton firm out of Philadelphia and now have, it's kind of hard to keep track. I think 1,200 lawyers in 23 offices around the U.S. That do a variety of legal work, ranging from litigation and corporate work to the handful of us that do land use and zoning work. Just a little bit about myself before we get started. I have a master's in city planning. In addition to my law degree, I worked for 12 years as a planner in various roles at the Atlanta Regional Commission here in Atlanta, mostly in land use and transportation, and then headed off to law school immediately after the Olympics and have been here at what we'll call the Troutman firm or Governor Sanders firm ever since. We have about an hour and a half today. I have given this presentation live in a somewhat compressed time frame, so I'm going to talk a little slower, maybe take a little more time, but I think we'll still have time at the end for Q&A. And as Beth Ann said, just put that in the chat when you think of a question. I'll try to get to them if I can during the session. All right. Now I'm going to try to go to the next slide. There we go. I am an attorney, so I'll start with a legal disclaimer. These are my opinions. They're not the opinions of my law firm, any of its clients, any of our clients' affiliates. I am not giving you legal advice. I'm just giving you some general educational information. Look at this quote for just a second, because I think it's important. This was a quote that when I was in planning school, my planning law professor showed it to us. I will admit that when I was in planning school, this was a brand new case. But I think it still holds true today that a lot of what we do as planners implicate the Constitution. And so like a policeman or a police officer, I guess I should say now, who needs to know the Constitution because what he or she is doing is affecting folks' rights. So too with us as planners, a lot of what we do affect folks' rights. So I think that's important to keep in mind, not just for purposes of this session, for purposes of the exam, but for purposes of what we all do in our everyday lives. So what are we going to do today? Well, obviously, I'm going to try to help you prepare for and pass the AICP exam. I'm taking names, and so hopefully when the results come out, everyone's name who was on this session will be among the new AICP members. So hopefully the next time I give a law session at maybe at the fall conference and hopefully in person, then you can start getting your CM credits and your all important CM legal credits in that session. So I'm going to help you prepare. This is not a Georgia specific legal session. It's not focused on the most current cases, because typically those are not in the exam, because the exam's prepared well in advance. I'm going to give you some thoughts on the process. I'm going to tell you a little bit about how I prepared back in the dark ages. This is an overview. It is not a substitute for your own personal in-depth focus or in-depth study. I'm going to focus on a few areas, but you have a ton of resources that are available for you. I'll identify some of those. Frankly, I use some of them in helping prepare for this session, so there'll be some overlap there. But you've got to study. You've got to put in the time in order to master the material, not just in law but in everything else, and then hopefully pass the test. So let me give you a few thoughts on the study process. This joke works a lot better in person, but the question is, how do you eat an elephant? And the answer is one bite at a time. Just like the proverbial eating the elephant, studying for the AICP exam it's a lot of material. You can't really wait till the last minute. You can't cram like you might have done for a particular test in undergraduate school or in graduate school. It's something that you really need to block out time to do. When I took the AICP exam when I worked at the Atlanta Regional Commission. At the time, there was only one real reference to use, and so I would take that book and leave ARC's offices after work every day, go over to the Georgia State Library across the street, and spend an hour or so most nights studying. And as luck would have it, I passed the exam the first time. Whether that had to do with my study habits or just dumb luck, I don't know, but definitely block out the time, make yourself a schedule, and try to stick to it as best as possible. Obviously, things come up over time, but again, you have a lot of resources to use. Sometimes that's a benefit, sometimes that's a curse, because you don't need to follow every rabbit hole down. You don't need to know the fact pattern of the 50 or so cases that are outlined in one of these, one of the reference materials. But again, invest the time. I think it'll pay off for you, both in terms of passing the test and in not having to take it again. So here's the areas I'm going to focus on today. I'm going to talk about some general terminology that you might see in some of the materials that you're going to look at. I'm going to talk about some foundational legal principles and decisions. Talk about the statutory basis for planning. Again, I'm not going to focus on Georgia per se with our zoning procedures law and that sort of thing. I'm going to talk a little bit about the legal context of a plan and distinguish that from the codes and the regulations that are used for plan implementation. So let's talk about some general legal terminology and practices. The plaintiff and defendant, you need to know these terms. The plaintiff is the person that is pursuing a lawsuit. The defendant is the person who is being sued, and can be a person. When I use the term person, that can be a natural person, or it can be a person acting in their official capacity, or it can be an entity. An appealable decision is a decision that is made by some decision-making body. It could be a zoning board of appeals, it could be a county commission or a city council. but it is a decision that can then be appealed to a higher body, whether it's a superior court, a federal district court, a federal circuit court. Ultimately, the last appeal would be to the U.S. Supreme Court. Very, very few decisions reach that place, but an appealable decision is one that is ripe for review by a reviewing body. An appellant and appellee, this has to do with a decision that's being appealed. The appellant is the person who lost below and is continuing to pursue the case. The appellee is essentially the defendant of the appeal. An appellee may not have been the defendant in the original case, so keep that in mind. Difference between a constitution, a statute, and an ordinance. It's important to know that. Constitution, whether it's a Georgia Constitution, a state constitution, or U.S. Constitution, is the sort of baseline framework. A statute is something that is a law that is passed by either the federal government or a state government, and then an ordinance is a local law. A case is simply, the reported decision, if you will, and every case has facts. Facts are distinguishable. It's important to keep that in mind. It's important to understand the facts of a case. The holding is the decision that the court makes, the sort of point of law that the court ultimately settles on. A de novo proceeding is a proceeding that starts anew. Here in Georgia, and I think nationally, a zoning decision, a decision to zone or not to zone a piece of property, typically results in a de novo proceeding before a reviewing court. What that means is you can introduce new evidence. You can bring in new facts, you can bring in expert witnesses, that sort of thing. The court is basically starting anew and looking at the issue. That's distinguished from a review on the record. And that is typically what happens when a court is reviewing a variance decision. It's also what happens when a court is reviewing a telecommunications decision, where they're simply looking at the record below. And that's typically also what happens in appeals to higher courts, is they're really looking at the record. They're not retrying the case. A jury trial, a bench trial, and finder of fact are all sort of related. Jury trial obviously is when the court impanels a jury of individuals from that jurisdiction, and that jury really tries to distinguish fact from non-fact. We'll call it, or the most compelling facts from less compelling assertions. Bench trial is when the judge, in fact, is the finder of fact. Bench trial, the judge is both the finder of fact and the ruler on the point of law. So keep those in mind as you move forward. We're going to go through all of these, or most of these, I will say, in a little more detail as we move through the next hour or so. But I wanted to just sort of lay them out, the things that you really should know in preparation for the exam. Should know a little bit about the U.S. Constitution, but particularly the First and the Fifth and the 14th Amendments. State constitutions, there are a few cases that we'll talk about that really rely on the state constitution. Those are typically, I think, the New Jersey state constitution, and a couple of cases that has provisions that deal specifically with fair housing. should understand a few federal laws and regulations, such as the Religious Land Use Institutionalized Persons Act. Regulations are those things that an agency will prepare, put out for review, and adopt to implement those laws. Same thing at the state level. State laws often have an impact on planning and zoning decisions. And then the regulations are those rules that are passed by state agencies. Local ordinances, again, I think I mentioned this earlier, those are things passed by a city council, laws that are passed by a city council or a county commission or a board of aldermen or whatever they might call it at the local level in the individual jurisdictions. And then there's case law, and we'll talk about that. Case law is really the way courts sort of explore the gray areas when you look at all those things above and try to determine what those really mean when they're applied to a specific set of facts. Go into that other column. We're going to talk a little bit about due process. You should know the difference between procedural due process and substantive due process. You should also know about equal protection. That is treating folks who are similarly situated the same, or at least having a compelling interest to treat them differently. We're going to talk about takings. I would be reasonably sure that something that you're going to have a law question on the exam having to do with takings. Two big concepts in that have to do with rational nexus and rough proportionality. And don't get hung up on those terms right now, because we're going to talk about those in just a few minutes. But takings typically involve the 5th and 14th Amendment to the U.S. Constitution, whereas cases dealing with expression, religion, speech have to do with the First Amendment to the U.S. Constitution. So let's jump into those constitutional concepts with regard to due process. The first is procedural due process. And what procedural due process means is that when a decision's being made that will affect an individual's property or a property that is owned by an entity, that entity or those persons in the legal sense are provided with notice and an opportunity to be heard in a fair hearing by an impartial tribunal. That's a keystone of decision making when you're dealing with property rights. Now, substantive due process and procedural due process, I think, is fairly easy to understand, and we'll talk about that in just a second. Substantive due process, it really asks the question, does the action that is being taken or the law that is passed by the local government bear a rational relationship to a legitimate governmental purpose? And I put those in quotes because those are really the terms that the courts have used. And so that asks the question is, it's sort of the straight face test. If you can stand in front of a judge and provide a reasonable explanation of why the government is taking the action it is, then it will probably, and why that is related to a legitimate purpose of the government, then that will probably pass that substantive due process test. Again, we'll talk about that a little bit more. And again, I'll say this probably several times, no substitute for looking at these issues in more detail yourself. So procedural due process, that's the reason we put up signs saying there's a public hearing. I put this up, and the the words on this are not important. What's important is that it provides notice that something is going to be happening. Looks like in the city of Kingston, having to do with that particular property. So it's the reason we provide signs or put up signs. It's the reason we put notice in the paper, a public notice in the paper. It's the reason some jurisdictions require that the neighbors be notified, either by the applicant or by the jurisdiction staff itself. It's the reason we have public hearings on zoning matters, and it's the reason that those public hearings are, in theory, held before a body that is impartial, that is not biased in one way or another, and does not have its own self-interest in mind when it's making that decision. It's also why we have equal amounts of time for applicants and opponents to decisions, is all providing that important procedural due process for not just the applicants, but for others in the community whose property may be affected by the decision. So one of the sources that you have, one of the resources you have is a list of cases that are that APA and AICP have put together relating to planning and zoning law. I'm going to hit on a few of these. I'm not going to do a particularly deep dive on any of them, simply because there are a lot of them, and we could spend the whole now almost hour remaining talking about those. So let's talk about a few of these notable due process case. First is Eubank versus City of Richmond. And in this case, this had to do with an ordinance that gave one set of property owners the ability to impose setbacks. The facts generally are City of Richmond passed an ordinance that basically said that by a vote of 2/3 of the property owners on a particular street, those property owners could set the setback for other properties that were being developed. And the court questioned the impartiality that that majority of folks who were imposing setbacks on others, because even if no bias is shown, there's a potential for bias. There's a potential for some wrongful motive in this vote in the setback. So that decision is not being made by the quote impartial tribunal. So anytime you see a situation where one set of property owners is given the right to make rules that affect another set of property owners, your due process alarm should go off. The second one is similar, where the ordinance allowed the location of a home for what they call the aged and poor, and remember this is a 1928 case, was only allowed in a neighborhood if those neighbors in the area actually consented to it. That was what was called an unlawful delegation of authority. That's the local government essentially saying, we're not going to make the decision, we're going to let the neighbors make the decision. Now, that's different than what we typically see in jurisdictions now. Certainly the neighbors have a voice in that decision-making process, because we don't want to deprive them of their procedural due process. But the decision needs to be made, again, by the governing body that is lawfully empowered to make those decisions. We'll talk about a couple more here. This next one is an interesting case in that the property owners wanted to do a subdivision along the seashore, or along the, I guess it was the bay in Connecticut. And they wanted to basically have, the people's backyards back up to the water. And there was a draft plan that the community had in place that actually wanted to put a road right by the water. And in denying the request of the applicant, the Board of Zoning Appeals relied on this draft plan, said, well, we have a draft plan that says we're supposed to have a road there at some point in the future, so we're going to deny this request based on that draft plan. And again, that violates due process because it was a draft. It had not been formally adopted. It was not. It had no formal standing and should have had no effect on the decision. And I know that just from personal experience that occasionally that will come up in local government decision making. They'll say, well, we're working on our comprehensive plan. We haven't adopted it yet, but the draft says that this area has to have this particular type of land use. That violates due process. The last one that I want to talk about is this Welton versus Hamilton case. Here, there was a statute in place that basically gave the Board of Appeals complete discretion on decision making. It didn't have any rules. It didn't require them to use certain criteria for the decision, and so it was also seen as an unlawful delegation of authority by the City Council to the Board of Appeals. So if you see a situation where there are not standards used for decision making, then that should be a red flag as well, and could be either an unlawful delegation of authority or simply a straight out violation of due process because of the unbridled discretion that it grants. All right. Moving on, substantive due process. This is the more, somewhat more complicated, but you're all smart people, so I'm sure you're going to whiz right through this. Again, I said that the question that you ask with regard to substantive due process is, does the action that's being taken bear a rational relationship to a legitimate governmental purpose? And here I've listed a number of legitimate governmental purposes: protecting health, safety, welfare, morals, property values, quiet enjoyment, etc. And rational, it does not mean necessarily it's the best relationship. It doesn't mean it's a perfect relationship. It doesn't mean that if I was doing it, I wouldn't do it differently. It just means, is it conceivable? Is it reasonable? Is it a believable relationship between the action and that legitimate governmental purpose? A few cases that we'll talk about, here. Here in this Koontz case, again, this is in the materials that you can get from APA. Here, the issue was that the ordinance gave homeowners some consent rights regarding billboards. Now, you're probably thinking back, well, what about that other case where with the setbacks? And you're absolutely right. But here's a little bit different because you have to look in part at the year this was passed, billboards looked very different. Billboards were essentially, a sort of a lean-to shape of wood with things painted on the side. And it was considered a commercial use. And this was, excuse me, a completely residential area. So it wasn't one set of property owners in that residential area having the right to dictate what other property owners do. It had to do with the introduction of a commercial use into that area. And because of this sort of the way that billboards were constructed, then you literally could have people, standing inside the billboard, engaging in, loitering, criminal activity, immoral practices, and of course you could end up with trash and thing accumulating in there. So that did not violate due process, because again, one purpose of government is protection of health, protection of safety, protection of property values. And this ordinance was seen by the United States Supreme Court as having some rational relationship to maintaining those things. Likewise, in Village of Belterre versus Barras, which is a more recent case, and I'm sure that pretty much every one of you who works for a local government has a definition of family in your zoning ordinance. And same was the case of Belterre versus Barras. This was set in New York. The State University of New York at Stony Brook was next door. This jurisdiction had only single-family homes. It was a small village, only single-family residential. And so they passed an ordinance that defined family for purposes of restricting land use to one or more individuals related by blood marriage or adoption, or no more than two unrelated individuals living together as a household. This was challenged. It also specifically prohibited things like fraternity houses, boarding houses, those sorts of things. Again, this was intended to maintain the peace, the serenity of this suburban jurisdiction, to avoid things like loud parties, parking issues, littering, those sorts of things. There are a lot of things the Village of Belterre could have done in terms of passing a litter ordinance or parking restrictions, those sorts of things. They chose this course of action. And again, the U.S. Supreme Court ultimately found that this had some rational relationship to the legitimate governmental purpose of protecting the values of the community. Again, go to your own ordinances, and I bet you'll find some jurisdictions will have as many as 6. Some jurisdictions, I think, still have as few as 2. So let's move on. Again, this isn't a deep dive. We're sort of skimming the top of a lot of these. So let's talk about the constitutional concept of equal protection. And again, this means treating those that are similarly situated, easy for me to say, treating them the same, or if you make distinctions, only make those on legitimate grounds. It also stands for the proposition that distinctions based on a fundamental right or protected class status are unconstitutional unless there's some compelling reason, and that's a term of art, some compelling reason for treating folks differently. All right, a couple of cases here as well. One that you really probably need to know. That Eubank case having to do with the setbacks was also an equal protection case because everybody was similarly situated. And the question became, well, how can one set of folks who already live there impose a different set of rules on folks who want to come into that community? So it's also an equal protection case. Village of Euclid v. Ambler. This is the seminal case that held that the mere enactment of a zoning ordinance, of a general zoning ordinance, is a valid exercise of police power and doesn't violate either due process, I could have put it in that section as well, or equal protection. It makes distinctions, but it makes them on legitimate grounds. And this is the case that the term Euclidean zoning came out of this case, where you have different zones for residential, commercial, industrial type of uses, and you treat those folks differently, but it's on legitimate grounds according to the U.S. Supreme Court. All right, let's move on to takings. I said earlier that this arises out of the 5th and 14th Amendments to the U.S. Constitution. You may want to take a look at those just to refresh your memory. And the question that courts ask is really that a regulation affecting regulations bring about a taking of property if they go too far. And what the courts have wrestled with, and what you may end up wrestling with a little bit as you review, is the question of how far is too far. And there are a number of cases that we'll talk about here. The first one is the Penn Central case. This is the famous case that had to do with plans for a modern office building that was going to be on top of Grand Central Station. And those plans were rejected. The Penn Central Transportation Corporation brought suit against the city of New York, saying this was a taking. And the court said, well, no, let's look at this in terms of these factors at the bottom. The economic impact on the plaintiff, the extent to which the regulations interfere with these distinct investment-backed expectations. Again, that's a term that you'll see recurring. And then the character of the government action. Yes, the plans were rejected, but there was in fact a comprehensive historic preservation plan that was adopted. It was not a draft plan. It had long been adopted. And this plan allowed the developer to take the air rights above Grand Central Station and either sell them to someone else or use them themselves to increase the density in another location. So the court recognized that there might be some economic impact, but was not sufficient to bring about a taking. And while the people who bought Grand Central and want to build the tower probably did have some investment-backed expectations that they could just put up this tower, again, the ability to transfer those development rights, reduce that interference, and the character of the government action was consistent with its comprehensive historic preservation plan. Here, this first English Evangelical Lutheran Church case, we'll call it the first English case so we can save a little time, involved a church camp near Los Angeles, and there's a big flood, and it destroyed some of the camp, and the church wanted to rebuild the camp, and the court said, well, wait a minute, we're not going to let you do that yet. We want to do a thorough sort of flood impact study determine those areas that are more flood prone and those that aren't, so that when you rebuild, you can do it in a way that's safer. And the church went to court. Ultimately, this went to the United States Supreme Court, and they basically saying that all use of the property had been taken by this action. And it's true, all use of the property had been taken. And so this is an interesting case in that the US Supreme Court said, if all use of property is taken by governmental action, monetary damages must be paid. But what the court did, instead of saying, so you've got to pay, they remanded it back to the Court of Appeals, probably the Circuit Court of Appeals for California, to determine whether a taking had occurred. And that court determined it had not, because it was only a temporary taking of that property, and it was for the purpose of allowing this flood study to proceed. Here we come with our rational nexus and rough proportionality test. Nolan versus the Coastal Commission. This is a situation in California where the statute said that the coastal development in this particular area had to maintain, if you had coastal development, you had to provide for a view of the ocean. The Coastal Commission instead demanded that the Nolans provide a physical pathway through their property to allow access to the beach. And the court said, well, wait a minute, if the statute says you've got to provide views, then there is no rational nexus between that and demanding access. So the impact of the Nolans building their house, per the statute, would be mitigated by providing views to the coast as opposed to providing access. So that established this rational nexus case. And again, you probably want to look more closely at this case because I think it is a very important takings case. We'll jump down to the bottom, even though it's a later case. This Dolan versus City of Tigard in Oregon. This involved the small expansion of a hardware store. And when the hardware store owners came to the city asking for this approvals for this small expansion, the city asked them basically to provide land for a bikeway, provide a number of things that the court ultimately said this is not proportional to their impact. They really want to do a small expansion to this hardware store, and the impact of that the city's demand or request for mitigation is disproportional to the actual impacts of the expansion itself. So again, that's a case you want to look at. Lucas versus South Carolina Coastal Council. Remember, if you think back to that first English case, this is sort of taking this a step further. Mr. Lucas bought the last couple of lots on the Isle of Palms near Charleston. At the time he bought the property, if you look down the beach one way or the other way, there were houses built on all the adjoining lots. He wanted to put two houses on those lots in roughly the same location. The South Carolina passed a law presumably for coastal protection, that essentially moved a no-build line from this ocean side of his lot to the rear side of his lot. And so, he paid roughly $1 million for these properties, and he could now have a picnic on those. It was about all he could have. And the U.S. Supreme Court ultimately said, no, you've taken all the economic use of this land. It's a full regulatory taking. This is now called a Lucas type taking. And the South Carolina Coastal Council had to compensate Mr. Lucas for this taking. There's an interesting backstory or sort of follow-on story to this, that the council actually took possession of the lots from Mr. Lucas. They paid him for those lots, and then turned around and sold the lots for development so they could recoup their losses. The Tahoe case, another Supreme Court case from 2002, and it's similar to that first English case in that the Regional Planning Agency, excuse me, passed a moratorium so they could prepare a comprehensive land use plan for the Tahoe area. Lawsuit was brought, and ultimately the court said, well, the mere enactment of a moratorium does not affect the taking of property. We have to look at things like the duration of that moratorium, the purpose of that moratorium, those sorts of things, the governmental interest involved, the individual's property interest involved. This was a temporary moratorium. And ultimately, the U.S. Supreme Court again said no, simply enacting a moratorium, just like in the mere enactment of a zoning ordinance, doesn't affect a taking of property. You have to look at it in more detail. All right, Koontz case. This is a little more recent, and you'll find a lot of these cases are fairly old, but they're old ones but good ones, and they're ones that you're going to be asked about. Here, the developer of the property, the Koontz family, and I think Mr. Koontz actually died while this whole thing was being appealed, but his estate continued on and wanted to develop some property. St. John's River Water Management District said no, unless you give us money for improving things elsewhere. And the Koontz family said, no, we're not going to pay that, whatever it was, $50,000 or whatever it was back then, for you to do these improvements that have nothing to do with our land. And so the permit was denied. And this was an interesting case because the Supreme Court held that even if the permit is denied, if the sole basis for that permit denial is that the condition or the demand of the local government would violate that rational nexus and rough proportionality test from Nolan and Dolan, then the government is liable. And again, look in more detail at this case. And this had to do with money, obviously, not with providing improvements on that site. It says recent here, 2015 in legal terms, it probably is. This is what's called a physical takings case, the Horn case. Essentially, this had to do with raisins. The Horns grew raisins. they were required by a regulation by the Department of Agriculture, essentially to sell some of their raisins at a deep discount to the federal government, presumably so the federal government could afford raisins and keep the price up. But they said, no, this is a physical takings case. And in fact, the U.S. Supreme Court agreed that if the government is taking personal property, it still is required to provide compensation. Another case, another takings case that I wanted to touch on briefly, and this is the Murr case from Wisconsin, which was decided about 5 years ago. And the Murr family owned adjacent lots on the St. Croix River, actually on the lake that's an impoundment on the St. Croix River. They had a vacation cabin located on one lot, and the state passed a regulation. Pardon me. The state passed a regulation that prevented them the ability to sell Lot E, so they could do improvements to their family home on Lot E. I'm sorry, on Lot F. They sought variances, they were denied, and they said, well, that's a regulatory taking of Lot E, which you've now effectively merged with Lot F, and you owe compensation. And here's a picture of that. You can see Lot E in yellow, Lot F in green, and the cabin right there. They're both slightly substandard lots, and the regulation effectively merged those and said you can only have one cabin on that combined Lot E and F, or parcel A and B. So they looked at whether the lot should be considered individually or as a single parcel, to determine whether there was a taking, and the court determined that the combined parcel was the relevant unit for the takings analysis, and no taking had occurred, and it set out a number of factors regarding that, how the land was treated under state property, the characteristics of the land, and so forth. And that, in fact, is a picture of the Murr's cabin, and you can see it was, from this one, it was quite the party place. I still haven't figured out why all those little fake hobby horses are in this picture, or why that guy in the back right is wearing a tux tie and no shirt, though it may have to do with the fact that that may not be his first beer of the day. All right, so let's switch gears a bit and go to First Amendment cases. Again, these have to do with freedom of expression, freedom of speech, freedom of religion, that sort of thing. And expression and speech are considered essentially the same. In those First Amendment cases, freedom of speech is important for sign regulations, as well as adult entertainment, which is expression. And then the freedom of religion is often based on the Religious Land Use and Institutionalized Persons Act, which prohibits a substantial burden on religious exercise unless it's what the courts call the least restrictive means to further a compelling government interest. And courts have found that usually ordinary zoning is not a substantial burden. And by that, I mean things like any house of worship in a residential area having to get a special use permit, something like that. may not rise to the level of violating the act. So the bottom line here is that you can regulate religious facilities, you can regulate signs, you can regulate adult entertainment, but you have to be careful about doing that. This is one of the first cases that addressed First Amendment in the context of adult entertainment. And here, the city of Detroit had an ordinance that said you have to have at least, I can't remember what the distance is, but we'll say, 1,500 feet, whatever, between an adult theater and other particular uses or a residential area. And for purposes of that, they looked at sort of secondary effects of these adult entertainment facilities. They looked at, they did not want a sort of a, I think in Boston it's sort of called the combat zone, where you have a lot of adult establishments packed in close together. They just did not see that as desirable, and they were able to demonstrate to the court that it wasn't desirable if you wanted to protect the community. So basically, the bottom line in this is that you could have adult theaters, but they had to fit within particular standards having to do with distance to those other regulated uses or residential areas. If you know one sign case, this is the one that you know, and for those of you who work in local government, you probably, or have worked in local government for a number of years, you've probably had to deal with this. But let me just say one more thing about the previous case. You can go back to it, yeah. Dealing with First Amendment cases, particularly things like adult entertainment, the ordinance has to be narrowly tailored. It has to serve a compelling interest, and it should be evidence-based. All right, on to read. Again, not as recent as we would consider in real time, but in legal time, it is fairly recent. Here, the general facts of the case are Pastor Reed and his church were a storefront type church. They didn't have a set location. So they, every weekend, Pastor Reed or one of his parishioners went around and put up signs in different locations saying, essentially, church is this way, with arrows. And the town of Gilbert had a sign ordinance that treated signs differently based on the purpose of the sign and the topic of the sign. And the court ultimately found that you cannot regulate based on content, and that if you have to read a sign to regulate it, you are regulating content. And let me show you a little chart. I apologize, this is a little out of focus, but the source material that I got this from was a little out of focus too. So here's what the city's ordinance basically said. You could have an ideological sign up the whole time saying the end is near, and you can have it up for time immemorial. In connection with an election, you could put up signs, vote for me 4.5 months before the election, and you could keep them up for 15 days after the election. If you had a homeowner event, a homeowner association event, you could put it up for 30 days ahead of time for your homeowners association picnic. You're supposed to take it down within 2 days after the event. Real estate sale, as you can see, weekend open houses, you could put them up 16 hours ahead of time, but you had to take them down within a day and a half. And then you get down to Pastor Reed and his congregation. He had to put up his sign no sooner than 12 hours before the service and take it down within an hour. Now, I'm the son of an Episcopal priest, and I know if my dad had to go around, taking signs up 1 hour after the service, that just wouldn't happen, because there'd still be people hanging around the church, or he'd be tired from doing 3 services on Sunday morning and decide to wait to pick them up. But you can see here that based on the content of the sign, that the treatment was different, and that again, the court said that violated First Amendment because it was content based. You want to regulate signs in a content neutral manner. I said at the outset we're going to talk a little bit about state constitutions, and this is the case I was referring to as the Mount Laurel case. And of course, there are a series of Mount Laurel decisions. I encourage you to be familiar with all of them. Excuse me. And here, the courts found that under the New Jersey Constitution, community has to provide its fair share of low and moderate income housing. There was some interesting facts in that case, in that the township of Mount Laurel, one of the, I don't know if they call them aldermen or town leaders, one of the members of the governing body, was on record for basically saying, we don't want to become the home for the county, saying things that indicated that a prejudiced a discriminatory attitude toward low and moderate income housing. And so they had this pattern and practice of excluding multifamily dwellings, and was determined to be discriminatory by the New Jersey Supreme Court. And in fact, the court, as I recall, the court has overseen the implementation of plans to make sure communities do provide their fair share. This Village of Arlington Heights case is distinguished in part because it was brought under federal law and had to do with the denial of I believe it was a rezoning for multifamily housing. And there was nothing in the record to indicate that there was a racially discriminatory intent or purpose. There was evidence that it did have a disproportionate impact on minorities, but in order to prove equal protection violation, the Supreme Court said that you have to have a racially discriminatory intent or purpose rather than simply some disproportionate impact. Eminent domain case. This is one that you probably are familiar with, even though I would say probably most of you were not practicing planning at the time, just based on the date, you may not have been. Here, the city of New London wanted to, for economic development purposes, I believe it was Pfizer, wanted to come into the city of New London, and the city started, buying property for this fancy schmancy corporate campus, and Suzette Kelo did not want to leave her little pink house with the great view. And ultimately, the city instituted eminent domain proceedings against her, and I think a few other folks. And ultimately, she was forced to sell her house to the city of New London. This was, in fact, not determined to violate the takings clause, even though the property was going to be used for, by a private entity. There's a case called Berman v. Parker in those materials that APA provides that you should look at. So essentially, the Kelo decision affirmed Berman and Parker, which had to do with the redevelopment in an area in Washington, D.C. That was largely, horribly substandard housing with outdoor toilets and things like that. However, there was a functioning and by every measure successful department store within that redevelopment area, and the court determined that the public use requirement of the takings clause expanded to include a public purpose. That public purpose being economic development and the redevelopment of an area in its entirety. Just a couple of things about one case about telecommunications law, and I practiced a lot in this area. I was not directly involved in this case, but you may want to look at this. I'm not sure it's in the materials, but it has to do with regulation of telecommunications facilities, and it states that when a request, whether it's a zoning or a conditional use permit or a variance, whatever, for a telecommunications facility is denied, the local government has to provide not just the notice of denial, but it has to provide written reasons for the denial. And that's so that the reviewing court can understand why that was denied. It doesn't have to be interestingly, it doesn't have to be in the same letter. Probably should be for practical reasons, but legally it does not have to be, but it does have to be issued and provided to the applicant in order to satisfy the requirements of the Telecommunications Act. Okay, we're getting fairly near the end here. Excuse me. Again, feel free if you have questions to put them in the chat. So let's talk a little bit about some of the statutory bases for planning and zoning that you want to probably be familiar with. Federal programs in terms of not just legislation, but the rules having to do with transportation, transportation planning, those sorts of things, housing, community development, block grants. Want to just be aware that many states have specific enabling legislation for planning and zoning. Here in Georgia, as an example only, we have the Georgia Planning Act, which provides for certain, has certain provisions in it related to planning itself. We also have constitutional provisions that allow local governments to zone. They do not have to exercise the power of zoning. So here in Georgia, we have the zoning procedures law, but in a number of jurisdictions, a number of states, South Carolina being, I think, the one that comes to mind immediately, they're actually model codes that if you go from jurisdiction to jurisdiction, their zoning ordinances are very, very similar because they're all working off the same model that the state had. That we do not have that in Georgia, but keep that in mind, that some jurisdictions have model codes. And then the final statutory basis for planning and zoning is just the city charter, the code of ordinances that the local government jurisdiction will pass. Talk a little bit about police power. We've actually used the terminology in some of the other discussion today, particularly that bottom quote, that's a legitimate governmental purpose, is protection of health, safety, morals, convenience, and general welfare. And if you go to your zoning ordinance, the adopting ordinance for your zoning ordinance, you will typically see some sort of clause saying that your jurisdiction, for purposes of protecting health, safety, morals, convenience, general welfare, property values, those sorts of things, that's invoking the police power, which is the sovereign power of the state to regulate and control my private behavior in order to protect and promote the general public welfare. I mean, that's why you have speeding laws and littering laws and a whole bunch of, pretty much everything government does is an extension of that police power to regulate, control individual behavior to protect the public welfare. And that has to be delegated by the state to counties and municipalities, which is why in Georgia, we have the delegation of that in our Constitution for zoning, planning and zoning. It allows us to do that. It doesn't require local governments to do that in Georgia. And then it also reserves to the state legislature the ability to enact procedural rules. So think of the police power as those things that government is permitted to do. Now this is kind of an interesting slide because there was a question about Dillon's rule on the AICP exam a few years ago, and so I put it on there. I have no idea if there's a similar question this year, but sort of distinguishing Dillon's rule from home rule. Dillon's rule is that local governments have those powers that are expressly granted to the local government through its charter or through state legislation. Those powers that are necessarily or fairly implied or incident to the powers expressly granted. So, for instance, if you have the power to adopt zoning ordinances, if those are expressly granted, then it's necessarily and fairly implied that you have the power to have a planning department in your jurisdiction. And then the third type of power is those that are essential to the purpose of that corporation being the local government, not simply things that are convenient. And so if there is a doubt as to whether that power has been granted, Dillon's rule is that it has not. That's in comparison to home rule, where local governments have essentially almost carte blanche to the extent they're not regulated through some sort of broadly applicable state law. Local governments have broad authority and powers related to matters of local concern. So bone up on that a little bit, because that I think is something that you'll need to know. All right. One of my favorite graphics of all time, my friend Greg Dale in Cincinnati gave that to me. Let's talk about the legal context of a plan. A plan can be authorized, meaning it's voluntary to do, or it could be required. Here in Georgia, we actually have plans are required under state law. To be a qualified local government in Georgia, you have to have a comprehensive plan. Now, importantly, from a legal perspective, the plan itself does not control land use. There are some instances where specific plans are incorporated by reference, or certain aspects of plans are referenced in zoning ordinances. But in general, a plan is just a guide. It's a general, non-binding guide. However, to implement that plan, local governments have the authority to, often have the authority to enact zoning ordinances, subdivision ordinances, maybe a UDO, housing ordinances, that sort of thing. So those are the legal ways to implement that plan through a variety of ordinances or codes dealing with zoning, subdivision. A lot of jurisdictions in Georgia have gone toward this UDC or UDO type setup as well, and then housing ordinances. All right, we're almost done. We'll have probably about 10 minutes if you have questions. If you don't, that's fine. We can all, get on with our day and start studying. There are, as I said, there are a lot more references now than when I was studying, and here they are. And this presentation is going to be up online, so don't feel like you have to copy down these at this moment. But the law section, that's the section I was referring to in the Chapter President's Council Study Manual. There's also a lot of reading lists. You can look at Planning Magazine. APA's Planning and Law Division has a list of what they call foundational land use law cases. There's probably substantial overlap between those and the law cases listed in that first bullet point. The PS reports, policy guides, all that stuff. You could reference and you could rely on. Again, you're eating an elephant over the next several weeks, so pace yourselves and feel free to look at those resources. Again, they're going to be posted, so you can get them at your leisure. So that's it, folks. Do study hard. I'm sure all of you will do well. All of you that are on this this presentation this morning, as well as any folks who may have had a conflict and are going to have to listen in at a later date. But I certainly wish you the best and look forward to seeing you in person at some upcoming event. And if you do see me, please introduce yourself, because all I have are your names on a list of participants. And for the most part, I cannot put the names with the faces, particularly when you use interesting abbreviations for who you are. Beth Ann, do we have any questions?
I don't see any questions in the chat, but if anybody wants to put in any now or unmute yourselves and ask the questions, if you're thinking of it, I'm sure somebody else is as well. So please feel free to do that. And while we're waiting, I just want to say thank you, David, so much for your help and always your willingness to do this presentation. It's much appreciated.
Happy to help you from a lot of questions all of a sudden. Megan Fowler, thank you very much. It's very nice. Thank you, Lauren Anderson. You're very kind. William as well.
Well, if anyone thinks of any questions later, please feel free to email Christina, or you can email David directly. His email is there on the screen. And we will go ahead and stop recording and get this recording up on the website in the next couple of days.